Hello everyone and welcome to today's Mondac webinar in association with Whitney Moore, discussing the key employment law updates for employers in Ireland. My name is Dan Sampaio and I'm joined by a wonderful panel to take us through today's discussion. Emma Richmond is a partner and co-head of the employment team at Whitney Moore. A specialist employment and business immigration solicitor, Emma has over 15 years of experience and is well known in her field. Emma advises Irish businesses and multinationals on all aspects of the employment relationship, from recruitment, drafting contracts and introducing HR policies, to advising on disciplinary and grievance issues, redundancies, unfair dismissals and discrimination claims. Marie-Claire Scullion is a highly experienced and skilled employment and business immigration solicitor with over 20 years of experience. She is a partner and co-head of the employment team at Whitney Moore, where she advises both Irish businesses and multinationals on various aspects of the employment relationship. Her expertise ranges also from drafting contracts and HR policies to advising on disciplinary and grievance issues, redundancies, unfair dismissals and discrimination claims. Now, before I hand over to the panel to begin today's webinar, a housekeeping item. You can submit questions to Marie-Claire and Emma by typing them into the questions pane of the toolbar on the right-hand side of your page. We will endeavour to answer as many as possible during our Q&A session. It's now my pleasure to hand you over to Emma and Marie-Claire to begin. Thank you.
Thank you, Dan. So, hi everyone, thank you for joining us today. The area of employment law in Ireland is always busy and full of change, and for HR and employment practitioners, and this year is no exception. There have been a number of changes that have affected the way employers have to draft their contracts, how they protect whistleblowers and put appropriate structures in place to do so, how employers are going to have to deal with remote working requests, flexible working requests, the work-life balance in general, and how to deal with new types of leave, such as domestic violence leave. This webinar is intended to be a high-level overview of those changes, focused on practical steps to assist you to comply with those obligations. I am Marie-Claire Scullion, a partner in Whitney Moore LLP in Ireland. Whitney Moore is a full-service law firm, and our core areas are in corporate and commercial, employment law, IP and privacy, and real estate, working in the sectors of technology, medtech, manufacturing and retail, amongst others. I'm joined today by my colleague and partner, Emma Richmond, and I'm going to ask Emma to kick us off today on the first topic, and perhaps we could move to the first slide.
Thanks, Marie-Claire, and thank you everyone for joining us this afternoon, and hopefully we can make this session as practical as possible for you guys, for people who are working in the area and dealing with these issues on a daily basis. The first piece of legislation that I'm going to talk about today is the Work-Life Balance and Miscellaneous Provisions Act, which is quite a long title, and as you can imagine with a long title, they threw as many things as possible in under it. Most of you will have been familiar with discussions over the past year about the Right to Request Remote Working Bill, and also the EU Work-Life Balance Directive. So effectively, this act is encapsulating all of that. It is addressing the right to request remote working. It also includes the right to request flexible working arrangements, and as Marie-Claire mentioned, special leaves such as domestic leave and medical care leave for medical care purposes. And overall, the aim with this legislation is to make Ireland a better place to work, recognising the importance of work-life balance and how we all perform better when we achieve that work-life balance. I'm not going to profess to have successfully achieved that, but I'll work hard towards it. And I think we're all trying to make our workplaces better in that regard. So Dan, if you could click to the next slide, please. So Marie-Claire is going to take me through some of the issues that we're seeing in our business and hopefully raise some of the questions that are coming across your desks as well.
So Emma, one of the questions that we come across a lot from employers at the moment and over the past few months is, do I need to agree to a request for remote working? What if it doesn't suit my business?
I think that's a really important one, and to an extent, our government has shied away from granting an automatic right to remote working. This is purely a right to request remote working. So an employee has the right to make that request. They must make it in writing. And from there, an employer must consider that and respond to the employee's request.
And Emma, what do I need to consider as an employer? What do I need to go through, and what do I need to tell the employee that I've considered, or do I have any obligation?
Yeah, so I suppose in terms of considerations, again, for those of you who would have been familiar with the Right to Request Remote Working Bill, you may recall that there was quite a long list in that on reasons why an employer could refuse and what they would consider. So far, there is a code of practice due from the WRC on this, and that may provide more guidance to employers as to what to consider. But as it stands, the employer just needs to consider their own business needs, the employee's needs, and then obviously tie it in with whatever's in the code of practice. And ultimately, if it doesn't suit the business, then the employer has the right to refuse the remote working request, but they need to set out their reasons for refusing it.
Thanks, Emma. And tell me, how does remote working differ from flexible working? Can you talk us through that?
Yeah, so remote working is purely where you carry out your work at another place other than your employer's principal place of work, whilst flexible working is the situation where you alter your working pattern or working hours.
Okay, and in what circumstances can I apply for flexible?
So I suppose what again is different in this legislation is that the right to request remote working is open to all employees, whilst the right to request flexible working is only open to those who require it for caring purposes in the case of caring for a child, or in the alternative, caring for someone who's in need of special care, and typically that is a family member who is living with that person. For children, where it's for caring for children, it's up to the age of 12 or up to the age of 16 in the case of that child having a disability.
Okay, and if somebody's needing it for caring needs, not for a child, what can I ask them as an employer? What type of proof can I look for? And, you know, is it sensitive? Am I allowed to ask for it?
Yeah, it is. You are allowed to ask for some proof that there's a requirement for that care, and typically it would be a medical certificate that you would request, and they would have to provide that for you.
And what about the employees that don't have caring responsibilities? Am I obliged to consider flexible working requests from them?
There's no obligation to consider flexible work in those situations, but obviously many employers will already encounter that and will have policies that address that. What we would suggest for all, similar to the right to request remote working, is that at this stage, employers and all of you on the call, if you haven't already put policies in place, that you are ensuring that you put those policies in place, and for existing policies that you look to amend them. And it's something that's regularly coming across both Marie Claire and my desk here in Whitney Moore, is reviews of those policies and assisting our clients to draft those policies so that they suit their needs and what already has been established within the business.
Thanks, Emma. Okay. Could we move to the next slide, please? So I'm going to talk to you a little bit about the EU Transparent and Predictable Working Condition Regulations of 2022. So these regulations have had a direct impact on how employers should be drafting their contracts of employment, and particularly have impacted probationary periods and specific clauses in that contract. As an overview, the core terms of employment, or the 5-day statement that must be given to employees within 5 days of commencing work, those terms have now expanded, and you have to include details around probationary periods, if applicable, and more detail around the predictability of their work and what their hours will be. As the name gives it away, the purpose of this legislation is to give transparency to employees that might have previously had variable working schedules, to allow them to have an understanding of what will go ahead in their working patterns going forward. In the contract of employment, the mandatory terms as to what should be in one of them have also expanded. Details of training should be included. Details of the work pattern, guaranteed paid hours of work should be included. If their working hours are variable, an employer should be identifying how much notice they will get before they start an assignment, and the employee will be entitled to refuse that work if they have not gotten enough notice. If an employee is working out of the state, information needs to be given in the contract of employment around that, the duration, what countries they'll be working in, what currency they're going to be paid in, and additional information has to be provided for posted workers also. The formality around contract has changed as well, so it must be signed and dated by an employer, it must be in writing, and a record must be kept of it being transmitted to the employee. It also must be given within 1 month of the commencement of employment rather than 2, which was previously the case. Now, this keeping a record ultimately, I believe, is going to be helpful for employers because it allows an employer to prove that an employee received and accepted the terms of employment and that there could be no challenge about that later on down the line, which often happens. Probationary periods particularly were of note because it came in under stealth really at the start of this year, and the maximum probationary period for employers is 6 months that they can have in their contract of employment. People who are already past that 6 months of employment by the 1st of February 2023 were automatically by law deemed to have passed their probationary period unless the employer had put something in writing beforehand. So as mentioned, you have a 6 month maximum period. There are limited exceptions to that where the probationary period can be extended for up to 12 months. Those exceptions are limited to 1, where it is in the employee's interests, or 2, if the employee has been out on protected leave and that leave is set out in the regulations. So for example, maternity leave or paternity leave, or statutory sick leave, for the period they have been absent during their probationary period, only that period of absence can be extended onto the probationary period. And as mentioned, 12 months is the maximum in any event. There's no definition of what is in the employee's interests, but in practice, I think it would be reasonable to assume that if the alternative for an employee is that their employment is going to be terminated, it is in the employee's interest in extending that probation. Now, what we're advising employers to do in these circumstances is to consult with the employees and to get it in writing that a discussion was had regarding either terminating the contract or extending the contract, and the employee has agreed to the extending of the contract as it's in their interest. This should avoid any challenge as to the extending of the probationary period at a later date. If we could just go to the next slide, please.
And in terms of Marie-Claire, I think most people at this stage, as you said, it came in somewhat under stealth and threw people off guard in terms of the probation periods, particularly. I know that was probably the most of our queries at the time. What are you advising employers to do at this stage in relation to these changes?
So we've been advising employers to review their probationary period clauses to make sure that they are compliant with regulations. So it's 6 months maximum. They can reflect that it can be extended, but either in consultation with the employee or reflect the wording of the regulations that it's in the interests of the employee. That will always be subject to, we believe, best practice, consult with the employee and get it in writing. Fixed term workers, those contracts have also been affected. So review those to make sure that any probationary periods you have for a fixed term worker are proportionate to the term of the contract they've been engaged in. So it's unlikely you need a 6 month probationary period for a 9 month fixed term contract, for example.
In terms of the other items that are coming up under the contracts, you know, what other headline issues from this legislation are you seeing in terms of queries?
The other key clause that employers have been concerned with is there is a prohibition in the regulations on restricting alternative employment. So most contracts of employment, as you know, have conflicts of interest clauses, but these need to be reviewed by employers to make sure that they are in line with the regulations. So it's not a strict prohibition. Employers are still entitled to restrict employees from working elsewhere, but they must have an objective reason for doing so. Now, the regulations helpfully set out what an example of an objective reason is. So health and safety would be an objective reason. Protecting business confidentiality would be an objective reason. What's important for an employer is to identify that objective reason and insert it into the contract of employment. So to show that it's not just a blanket restriction, it has been considered and it has been documented and brought to the employee's attention. Another change is that employees who have variable work patterns, once they have 6 months service and have passed their probation, they are entitled to ask for a different form of employment, more regular hours, for example. An employer is obliged to respond to that request within writing and within 1 month, and to give a reasoned response as to why they will or will not accept that request.
So I suppose from particularly in terms of this piece of legislation, your key takeaway, Marie-Claire, is that people need to get the contracts out, change them, update them, make sure particularly probation periods and clauses in relation to parallel employment are updated so that they comply with the recent regulations.
Absolutely, and that ties in as well with the new forms of leave that have been introduced, and the statutory sick leave, which I'm going to let you talk about next, Emma, will also need to be reviewed in terms of your contracts of employment. So the key takeaway is review and update those contracts of employment.
Thanks, Marie-Claire. Dan, if we could go to the next slide, thanks. So as Marie-Claire mentioned, I'm going to briefly talk about the Sick Leave Act. And again, as you may have seen, and for those of you who have experience of other jurisdictions and are part of multinationals, some of this Irish legislation is legislation that is long overdue, and to a large extent is bringing us in line with other European countries. So certainly in the context of, you know, right to request remote working and sick leave, statutory sick leave, these are provisions that are already provided elsewhere. The Statutory Sick Leave Act came in at the end of last year, and this obviously now puts some sick pay, statutory sick pay, in the provisions. I appreciate that many of you probably are in organisations which provide for an element of sick pay as it stands. However, it is important that you now ensure that your policies comply with the updated legislation.
And so, Emma, what do you say to employers that don't have sick pay policies in place?
Again, as with everything, you know, we will always advise that it's better set out in a policy. It's much easier to deal with any differences that arise between employees if the employer is transparent, clearly sets out their statutory or discretionary sick pay policies, whatever they may be, that it is specified in a policy so that there can be no confusion over what people are entitled to. As you'll see, the new Sick Leave Act incrementally increases the statutory sick pay from 3 days up to a maximum of 10 days. So I think it's important for people that even if you already pay, for instance, the minimum of 3 days, that you are putting in place a provision in your policy to say what discretionary element may be on top of that, or if there's a contractual element on top of that, that is clear.
Thanks, Emma. And just in relation to your slide there, I see that it's saying you have to pay up to a maximum of €110 a day. Who pays that?
That is a cost to the employer. And it is something that, you know, certainly small and medium-sized enterprises who may not have previously provided for sick pay, it is an added cost to their business. Obviously, employees after the designated period may be entitled to a social welfare illness benefit, but that is separate. So the statutory sick pay is a payment made by the employer to the employee. And if we can move to the next slide, I think we will hand back to Marie-Claire for the Protected Disclosures Act.
Thanks, Emma. So I'm going to talk to you about the Protected Disclosures Amendment Act of 2022. This is a significant piece of legislation that came in. By way of background, it is to harmonise laws across Europe to protect people who are disclosing breaches of EU law. And Ireland already had protections for whistleblowers in place. We had a 2014 Protected Disclosures Act. However, the statutory obligation for protections or having a policy in place related to public bodies only, whereas this piece of legislation affects all employers. I've highlighted some of the key changes that I think are important for employers to take away. However, there are a lot of changes within the Act, and so I recommend you familiarise yourself with them as well. Some employers are obliged to put in place an internal reporting channel. And if you are required under the Act to put an internal reporting channel in place, it is an offence not to do so. A second key change is that a worker can now apply to the Circuit Court to seek to restrain or injunct an employer from carrying out any act of penalisation. So previously this had only been limited to unfair dismissal, whereas now it is extended to any act of penalisation. So that is quite broad and raises the risk of litigation if an employer is penalising a worker for raising a protected disclosure. Thirdly, the burden of proof has changed. So previously, the employee had to prove that they were being penalised as a result of having made a protected disclosure, whereas now it is up to the employer to prove that it has not penalised a worker if they have made a protected disclosure. So it is assumed that the employer has penalised, and it is up to the employer to show that it has not made a penalisation of that worker. So these are very significant. Can we move to the next slide, please? So a protected disclosure, what is it? We know it as whistleblowing. Under the Act, the technical definition is that it is a disclosure of relevant information made by a worker who came across that in a work-related context and shows a relevant wrongdoing. In practice and in practical terms, what does this mean? What does a protected disclosure look like? What we most often see is protected disclosures relating to health and safety breaches in the workplace, or financial fraud, for example, in the workplace where one employee or a worker, somebody external from the organisation, is reporting that they've become aware of financial fraud. And this now extends to any breach of the European Act that is listed in the Act. So that extends to the likes of financial services, breaches of animal welfare legislation, breaches of data protection and privacy, and it still refers to any offence or failure to comply with a legal obligation. What is helpful is that the Act does specify that a protected disclosure is not an interpersonal grievance. So if one employee makes a complaint against another employee because they don't like the way they're being treated, that is not a protected disclosure. However, we do urge employers to be very cautious in treating grievances and what might seem on the face of it to be a grievance, as just treating it as a grievance without reviewing whether it is a protected disclosure. The reason for this is that oftentimes if there is a grievance from one person against another, it may also reference that that person is, for example, a bullying claim, that they are bullying a team of people, that they have created a toxic work environment, and now you're suddenly into health and safety breaches. So you do have to review each of these grievances carefully to ensure that they're not falling in under the realm of the protected disclosure. If we just move to the next slide, please.
So I think, Mary Claire, one of the things, one of the key changes in this is as to who can make a protected disclosure. And you might just take us through as to, is it just employees that can make a protected disclosure?
So no, it's not just an employee. It is defined as a worker, and a worker is past and present employees, but also includes volunteers. Now includes volunteers. It could be a shareholder. It could be a consultant who did some contract work with you. It could be a job applicant. It is somebody that came into the contact with the organization in a work-related context. They do not necessarily have to have a contractual relationship with the employer in order to be deemed a worker. So you need to be aware of that. That's what employers need to be aware of. It's not just the reports coming in from your employees to be aware of. It extends beyond that, and your policies and procedures should be available to all of those external people as well.
In terms of penalisation, I think this is one of the concerns for a lot of employers, and I suppose there can also often be a bit of confusion as to what is penalisation. If you could also give us maybe some examples, and particularly under the new legislation, what is now deemed to be penalisation.
So the definition of penalisation, it is very, very broad under the Act. Effectively what it means is a negative act against a person for having made a protected disclosure. So what is a negative act? An example would be Joe Bloggs made a protected disclosure. He was about to get a promotion, but we're not going to give him that promotion now. We have, for example, Jane has made a protected disclosure. She was due to go on a training course. We're no longer going to do that. And we're going to move her office down the corridor, and she's going to be excluded. She'll be ostracized by management as a result of having made that protected disclosure. It goes so far as to giving somebody a negative performance review, referring somebody for a medical report. These could all be seen to be acts of penalisation if a person has made a protected disclosure. For people external, so not an employee, it could be failure to renew a contract. It could be the early termination of a contract or blacklisting somebody. So for example, a contractor, you start, so that he or she made a protected disclosure, and suddenly they're getting a bad feedback. Now, they could make an allegation that you weren't happy with my performance, you didn't renew my contract because I made that protected disclosure. So it is exceptionally broad, and any negative action that is being taken against a person who has made a protected disclosure should be documented, and the objective reasons for those actions should be set out in writing so that an employer does have an objective and documented position as to why it took those actions. Because it's not to say that you can't take actions that may be necessary to terminate a contract, regardless whether somebody made a protected disclosure, but you should be in a position to be able to show why and why it wasn't related to that protected disclosure. Because where a person can show that it was alleged that it was penalisation, the remedies are now they are significant. As mentioned, they can go to the circuit court to restrain an employer from taking any act of penalisation. So if they're put on notice that their consulting contract is about to be terminated, they can try and apply to have that stopped in the circuit court, and the burden of proof is now on the employer to show that it wasn't an act of penalisation. So again, the importance of that employer documenting why it wants to terminate the contract is key in all of this. And I suppose just to point out as well that compensation, as under the previous regime, for an employee or somebody in receipt of remuneration, it's compensation of up to 5 years remuneration, and a new fine of up to €15,000 if a person isn't in receipt of remuneration by the employer. So the remedies and the penalties are quite significant for acts of penalisation.
And so at this stage, and Dan, you might move to the next slide, in terms of what the people on this call need to do, and who needs to do what. You might give us some guidance on that.
Yeah, so at present, if you have over 250 employees, you are obliged to put in place what is known as an internal reporting channel. That was effective from the 1st of January 2023. Employers with 50 employees or more have to have these in place by the 17th of December of this year. Employers with less than 50 do not have to put in the internal reporting channels. However, they do have to comply with other aspects of the Act. So what is the internal reporting channel? What are the requirements around that? Well, what employers need to be doing, if they haven't done so already, is they need to establish how they are going to provide a secure and confidential channel for somebody to make a protected disclosure. It will have to be GDPR compliant, ensure the confidentiality and privacy of that person. It has to allow the person to make the report either verbally or in writing. It has to make details of this internal reporting channel available to all, so not just for your employees. As I said earlier, this extends to all workers, so third parties to your company. Our recommendation to do that is to have it up on your website to make sure it's easily accessible for all. What is helpful under the Act is that an employer is not obliged to follow up on an anonymous report. That has often caused difficulties in the past where employers have received a very serious complaint, but it is anonymous and they don't know whether they should or should not investigate it. And this Act allows an employer not to investigate it if it is anonymous. So that has been very helpful. Getting back to the mechanisms of the internal reporting channel, timelines have been put in place as well. So this is all the structure that the employers need to be looking at now. And who is going to receive the report? Okay, because that person, whoever it is going to have to acknowledge it within 7 days. An employer is also obliged to appoint what is known as a designated person. So that person has to be independent, impartial, and competent is the word used in the Act. So it doesn't give the definition of competent, but presumably somebody that just will be able to deal with the report with a common sense approach, really. The designated person has a very important role. And I suppose it's important to note that it doesn't necessarily, it can be your HR department, it can be your CFO, your CEO, or it can be an external party. For smaller employers, you can share designated person services with others. You can share an internal reporting channels with others, so long as they are separate and confidential. But at this stage, employers need to be identifying who their designated person is. That designated person will carry out an initial assessment of the report to see whether or not it is a protected disclosure, because obviously all of these obligations come with a protected disclosure. But if it is just a grievance that is between two people, the designated person will make that assessment and go back to the person making the report within 3 months. The obligation is within 3 months, and say, look, I've assessed this report, do not believe that this is protected disclosure, and the company should deal with this under its grievance or dignity of work policy. Or alternatively, yes, this is a protected disclosure, these are the actions that I've recommended. Okay, and the person has to be notified in writing.
Thanks, Mary Claire. I think it is going to be a big challenge for employers to comply with this. It does put an added onus on employers to do this. Is there any easy way or tools that can assist an employer in complying with this?
Well, there are external providers, absolutely. If you don't have the capacity, be it time-wise, personnel-wise, if you don't to do it yourself, or it's just too much of a challenge, there are providers, software providers, who are providing platforms to allow that reporting channel be available to all workers.
Thanks, Mary Claire.
The designated persons can be outsourced also. That can be to your solicitor, to your accountant, so long as they fall within that competent and impartial heading. What employers really need to be cognizant of is you don't want an inference of bias that'll taint any protected disclosure that is made.
And just in terms, I suppose, going through protected disclosures and some of the challenges, certainly that we've been seeing, is there any advice you can give employers in terms of when they get a grievance in helping them spot a protected disclosure?
Well, I think training staff is on the Act and what a protected disclosure is key for that, and putting policies in place so that people understand what a protected disclosure is. A grievance might come in, and if somebody isn't aware that if it extends to health and safety breaches or breaches of data protection, that it constitutes a protected disclosure and it goes through a grievance process, the employer may find itself at the end of a challenge, and the fines and penalties are quite significant under the Act. So in terms of trying to assist employers getting there, it's really identify at this stage, if you haven't already, put your channel in place, identify your designated person, get your policies in place, train people on those policies, stick to your policies. No point having a policy drafted if nobody knows what it says or it doesn't adhere to it. Obviously, speak to any external sources, to your lawyers and otherwise, for guidance on that if you need assistance.
Thanks, Marie-Claire. Dan, if you could just move to the next slide there. I think, again, I know you've covered some of this in terms of some of the penalties for employers, but I think it's worth reminding people of the potential sanctions, and you might just take us through those as well.
Thanks, Emma. So yes, as mentioned, it's an offence not to set up the internal reporting channel. It's also an offence to breach the confidentiality of somebody who's made a protected report, protected disclosure. And anybody who hinders or attempts to hinder somebody making a protected disclosure, these can be found to be guilty of an offence which can attract a significant fine and or imprisonment. And that's separate to the civil remedy that a person will have, as mentioned already. So up to 5 years remuneration and or €15,000 for people not in receipt of remuneration, as well as potential circuit court proceedings to stop you from penalising them. So employers should take note.
Yeah, I think it's one of those pieces of legislation and an act. It's not a nice to have, it's a need to have. So I definitely think everybody needs to make sure they have a protected disclosure policy there and that it's complying with the new legislation.
Absolutely.
Dan, if you could move to the next slide. I think we'll now take some questions, and I think you're going to take us through those. I can see there's quite a few have come in on the chat whilst we were talking.
Yes, you are right. We've had a lot of questions in from the audience, which is fantastic. I just want to say, firstly, Marie-Claire and Emma, thank you very much for your presentation today. Really insightful, and I'm sure that our audience appreciated it. So if we move on to our first question from Barry. If a contract covering all the required terms is sent to an employee prior to commencing employment, does that cover the required for the 5-day and 1 month statements?
Yeah, I'll take that. So sorry, if they have provided a full contract of employment in advance of the employment starting, absolutely, yes. So long as they cover the mandatory terms and make sure that those contracts of employment have incorporated the new mandatory terms. And yes, your obligation will be met by doing that.
Excellent, thank you. Barry also asks, does a contract sent to employee via an e-signature platform such as DocuSign and signed by both parties via such a platform comply with these regulations?
Yes, under the new regulations, so long as it's in writing and there is a record of transmission, and it does include electronic transmission.
Excellent, thank you. This question from Victoria, re-probation. Would we have to obtain the employee's written request to extend so as to avoid any challenge? At what point should an employee request? can they do it on the day of consultation, even if on the day of termination?
So, sorry, do you mind just repeating that question?
Of course. It's a question regarding probation. Would we have to obtain the employee's written request to extend so as to avoid any challenge?
So no, you don't need a request from the employee to extend it. What I think employers should be doing, what we're advising people to do, is that if it's coming up to the end of the probationary period and the employer isn't satisfied, to say at that point, yes, you've completed your probationary period, it's to sit down, talk with the employee and to put it to the employee, look, we propose extending the probationary period, and like an email or a side letter, very short, just, we had a discussion on this date. It was agreed that it's in the employee's interest to allow them 3 further months to, in a probationary period, to assess if they are going to complete their probation, and the employee agrees to that. I think that would protect an employer in the event of a challenge down the road. But there's no requirement for the employee to request it, no. And this is just our advice as to best practice on how to deal with that piece of it needing to be in the employee's interests and documenting it from an employer's point of view.
Of course, excellent. And as we always say, if you do have any questions that you want to speak to Emma or Marie-Claire in more detail about, we do have the contact information in front of you, so please do reach out. We encourage you to reach out if you need to. This question comes from Sinead. If standard practice in my organisation is to pay sick leave in full, once it goes to 10 days, will I be required to continue this practice, or can I pay 5 days in full and 5 at 70%?
Yeah, so where that is changing, obviously, the minimum compliance is to pay the 10 days, the statutory sick pay at the 70% for 10 days. So in effect, under that proposed arrangement, you'd be paying above what's required statutory. So again, if you're changing your current policy, again, it's implementing a policy and adhering to your provisions which allow you to change such policies. Again, making sure that it's changing the policy as opposed to if you have it in a contract. Obviously, if you're going to change the terms in a contract of employment, there's different obligations on you in terms of as opposed to just changing the policy.
Excellent, brilliant. Thank you very much. Just looking, we do have a few more questions in here and plenty more time. So please do send in any questions that you would like answered. For the SSP, is there any prorate entitlement for PT workers? For example, if someone works 4 days a week, are they entitled to 4/5 or 3 days or the full 3 days? Quite a technical question there.
That's it. I suppose it depends on the days they're out sick. So they would be entitled to sick pay for the days that they would have worked. So, if it's not a day they would have been working, then they're not entitled to sick pay for that. As to how practically that is applied in terms of any return, I think, it should be something that your payroll can administer in compliance with the legislation.
Excellent, brilliant. Thank you very much for that, Emma. Sinead asks, if we have more than 50 employees, but half of these in the US and not on an Irish contract, do I need to set this reporting channel up? And I think that might have been in reference to something you were speaking about earlier, reporting channels.
Okay, and the protected disclosures. So if are they employed by the Irish entity, that is the figure that is counting here. So if the employees based in the US are Irish employees and are part of the Irish entity, then yes, you meet the threshold of 50 employees. If you are in part of a group, for example, and the Irish entity is employing 25 and the American entity is 25, in my view, then no, we're below the 50 threshold.
Excellent, brilliant. As always, if you do want to speak in a bit more detail, please do reach out after the webinar, but I think that was a fantastic answer. Thank you, Marie-Claire. Victoria asks, in respect of the Protected Disclosure Amendment Act, size company, Is that parent company or the employee size in Ireland?
So I think that's similar to the question we just had. So it's the employee count within the Irish entity. I believe that's addressing the problem. You can send me an email if I'm not addressing the question there, but I do think that's what you're asking.
Excellent, thank you very much. This question in from Brian. Do you have to provide an employee written confirmation of them passing their probation period?
Well, it's good practice too, but it will happen. If you haven't provided it in writing, they will be deemed to have completed their probation. So there would be no protection to the employer by not confirming in writing.
Brilliant. We'll go back to Barry for another question regarding the requirement that any extensions to probation must be in the interest of the employee. Is it not always in the employee's interest to extend if the alternative would be dismissal at the end of the 6-month period?
And yes, I would agree on a reasonable interpretation of that in the interest of the employee, that if the alternative is that you're going to dismiss the person, it has to be in their interests. We don't know how that's going to be interpreted though, so we do wait to see what a WRC adjudicator makes of that interpretation. But yes, I would agree with you. I think it's reasonable that if the alternative is to dismiss somebody, it has to be in their interests. That's why I recommend, however, that an employee acknowledges they've been told that, look, the alternative here is that we dismiss your employment. We're proposing to extend it by whatever time. Will you sign here to say that we've had, to confirm this?
And I think just to add to what Marie-Claire has said, I think what's important is that it's not just extended and no action is taken. So if it's in their best interest, that there's a reason for the extension. So if it is, for instance, that they haven't had an opportunity to prove themselves, or something has occurred that, like so many say in the instances of COVID, where people may have been hired and then it wasn't normal working arrangements. So I think it just has to be clear that there's a reason for that extension.
Brilliant, thank you very much. So we'll move on to a question for Jennifer. It's quite a long question, and you should be able to see it, Marie-Claire, in that chat. But I'll read it out for the audience. Must a protected disclosure be made as a protected disclosure? In other words, if certain complaints, reports are made by an employee but made as observations only, who is responsible for determining it is indeed a protected disclosure? Must the disclosure have come in through a particular channel to qualify as a protected disclosure? And if not, does the employer have an obligation to report?
Okay, so the protected disclosure comes from an employee to from a worker rather, but to the employer. It is intended for them to be making a report. So it's not just a by the by chat at the water cooler, oh, I'm concerned about the air conditioning health and safety issue. The person must believe that it's a relevant wrongdoing. They have to have a reasonable belief that there is a wrong occurring. Now, there's no requirement, even though you have your internal reporting channels set up, there is no requirement for the person to make that report in your internal reporting channel. And so that if they don't do it through the internal reporting channel, that you're not obliged to investigate it. You will be, an employer will always have an obligation to investigate a protected disclosure that is made, be it verbally or in writing. The best way for an employer to direct all of these protected disclosures is to direct them to their internal reporting channels, to publicize its availability, to make sure people are trained, that they understand that that is where the employer will recognize it and that's how it will deal with it. But you can't always make people do it that way. And so if somebody comes to their manager and says, I'm concerned because I saw Jane amending an invoice and I don't think that was proper, I think a crime is being committed or fraud of some sort, that will qualify as protected disclosure. And will need to be, now what the employer can do in that instance is say, thank you, I'm now going to put that through our internal reporting channels. And so can direct the protected disclosure through its preferred way of dealing with it, because it will have to be dealt with by a designated person. and so on, as per all of the other obligations.
Excellent. Thank you very much for that answer, Marie-Claire, to what I think was a very important question. We've had another question just in from Victoria. Could you seek to dismiss prior to the 6 months, for example, 3 months due to poor performance, or would you have to allow the full 6 months of working so as to allow the employee an opportunity to improve?
No, there's no obligation to have a minimum probation period. The obligation is to restrict the maximum probation period. So no, absolutely, if it's not working out, you can terminate during the probationary period in the ordinary way and in accordance with your contract.
Excellent. Well, we've come to, for now, the end of the questions in from the audience. Very lively Q&A session there. So thank you to both of you for taking the time to answer those questions in from our audience. As I say, I do encourage you to get in touch to Marie-Claire and Emma for any additional information that you might need. We're a little bit ahead of time, but we may be able to finish a little bit early here. What I would ask Emma and Marie-Claire at this point, if you have any closing comments or key takeaways that you'd like the audience to leave today's webinar with, if you could let us, if you could disclose those now.
Yeah, well, certainly I think on the legislation I've covered, and also in terms of Marie-Claire, the key is to, keep your contracts of employment up to date, your policies and handbooks, and obviously review them with your legal advisors. Please do get in touch with either Marie-Claire or myself if you don't have policies, you need to put them in place, or you need assistance in reviewing them, and we'd be delighted to assist you with that.
Absolutely, I second everything Emma just said. And thank you for having us.
Brilliant. No, thank you for joining us. It's been a real pleasure to have you with us today, and hopefully we can do it again soon. I'd like to say thank you as well to our audience for being with us today, and I wish you all a lovely rest of your day. Thank you and goodbye.
Thank you.
Thank you.
Bye.